Hundreds of people charged with felony fraud, accused of stealing from Minnesota's Medicaid program.
It is accountability to prosecute people.
But 5 investigates found defendants walked away with lesser charges on their record.
It's as if there had been no criminal prosecution at all.
If someone is charged with felony level fraud, shouldn't they have a felony on their record?
Tonight, 5 investigates is tracking fraud cases prosecuted by the Minnesota Attorney General's office.
Our team spent months reviewing hundreds of Medicaid fraud cases, and investigative reporter Kirsten Swanson discovered many defendants walked away with little record of the crime they committed.
This is a fraud case you probably haven't heard about. Gonzalez worked for MNsure, the state's healthcare marketplace. In 2020, investigators say the public employee manipulated data in a state computer system that allowed Medicaid funds to flow to a company she'd set up for her daughter. Gonzalez siphoned off more than $3,300 and was attempting to steal another $10,000 when she was caught. The state's Department of Human Services fired her, and 3 years later, the Minnesota Attorney General's office charged her with medical assistance fraud, theft by swindle, embezzlement of public funds, and misconduct of a public officer or employee. In 2024, Gonzalez pleaded guilty to 2 of the charges. A transcript from that hearing shows her plea agreement included a stay of imposition.
The defendant will be put on probation for a period of time.
University of Minnesota law professor and former prosecutor Amy Sweezy explains how it works.
If the defendant successfully completes all of those conditions and terms, that final felony sentence will not actually be imposed.
Right now, court records show Gonzalez convicted of a felony. But if she successfully completes probation next year, that felony will become a misdemeanor conviction.
It's an incentive for a defendant, particularly in the cases of a felony, to complete those terms of probation so that at the end there won't be a felony conviction on that person's record.
Gonzalez's attorney says his client has taken responsibility for what she did, is in the process of making amends, and will be off probation soon. But this case isn't an outlier. 5 investigates analyzed more than 250 Medicaid fraud cases charged by the Minnesota Attorney General's office.
Funds are paid to.
We found nearly 80% of the convictions fall into this category. The defendant completes probation, and the felony is knocked down to a misdemeanor. And at least 70 other convicted fraudsters had their criminal conviction dismissed after probation.
It's as if there had been no criminal prosecution at all.
If someone is charged with felony level fraud, shouldn't they have a felony on their record?
That's not something that the Attorney General would ultimately decide.
Keith Allison is Minnesota's Attorney General. His office is responsible for prosecuting Medicaid fraud cases.
These things are decided by court discretion in sentencing.
But as the prosecutor's office, you often set the tone for those cases.
I think that it is an adversarial system that involves both the prosecution, the defense, and the court.
Allison pointed to the Minnesota Sentencing Guidelines, a set of standards judges use when deciding a defendant's punishment. Offenders with little to no criminal history, convicted of theft of any amount, receive a non-prison sentence.
How is that system working?
Well, because the person was charged, was brought into the court system, had to maybe make several court appearances, had to plead guilty to criminal wrongdoing in front of the whole wide world. It is a serious consequence. It is life-ruining to be charged with Medicaid fraud, even if you somehow manage to complete probation without a permanent felony.
This year, the legislature created a new crime prosecutors can charge: felony of medical assistance fraud over $1 million. It was part of a bill backed by the Attorney General's office. Now, just last week, Ellison wrote this letter to the Sentencing Guidelines Commission asking them to rank that felony among the most severe offenses. He argues that this provision will apply to a very narrow, rare class of cases, but those with especially egregious content, but one that the legislature intends to be treated more seriously with greater penalties at sentencing than other economic crimes. So the higher the severity in the sentencing guidelines there that you saw, the more likely it is that defendants will serve some prison time if they're convicted.
Okay.
What happens to the taxpayer dollars, the money?
Yes, that's right. That's the big question, right? In the vast majority of these cases we reviewed, the court ordered these defendants to pay back what they stole. But there are many challenges to clawing back those public funds, and also questions about how much money is actually back in the hands of the state. I'm going to be back on Monday with that reporting.
Okay, Kirsten Swanson, thank you very much. Looking
Thank
forward
you.
to Monday. Now, our 5 Investigates team is hard at work looking into waste, fraud, and abuse, just like this. If you have a tip for our reporters, we'd like to hear from you. Please send your ideas to us right now at KSTP.com.